So Des Carty is back on the phone. How are you, Des?
I'm grand, John. Yourself?
Very good, thanks. Very pleased with the response we've got to our introductory piece. We chatted for about an hour last week and about, I suppose, the control system that is in place in this country and why so many people are struggling. And we then went on to give a bit of an intro to your book, Irish Life and Me, which is basically an expose or a case study of one man's battle with Irish life and permanent. And while we haven't gone into the details of the case, and we will start to do that now, basically in our story we're at the stage where we have a guy, he's in trouble and he's decided to strike back at the banks, and all kinds of hell break loose then. And that brings us up to chapter 1 in Irish Life and Me. So let's talk about that. It's entitled The Lovely Laura Skelly.
Thanks, John. Yeah, it's a nice intro, and chapter 1 is primarily focused around the first letter that was sent to the man. And I'd like to give the man a name, although it's not his real name. We'll call him Tom. Okay. And Tom was sent this initial letter, and the letter basically is a letter that an awful lot of people will get. It's the 28-day notice, or some people get a 21-day notice or a 14-day notice from the bank, and telling them and informing them that if they do not give all the money back, whatever amount is, be it arrears or full payments of the mortgage or the debt involved, that they will then proceed to taking legal action. So pretty standard enough. The way we'd come at this, when Tom presented this letter to us, we got him to sit down and analyse the letter for himself, and then we specifically directed him to 3 specific bits of legislation which are worth mentioning. One is the Data Protection Act, I think it's 1997, the Data Protection Act is 1998-2003, and the Freedom of Information Act 1997. And then the third one we recommended that he read, and I think he really should read, is Non-Fatal Offences Against the Person Act 1997. Now it's a long-winded way of saying, well, the Non-Fatal Offences Against the Persons Act 1997 tells people what their rights are in relation to coercion, harassment, bullying, so on and so forth in context. So it's the 3 bits of legislation that if you're going to go down this road, you need to read them, you need to go back and reread them, use a pen, a highlighter, a marker, and then sit down after you've read them as best you can. Of course, we're not expecting people to know these things verbatim or off the top of their head, but we do expect people to sit down and read these things and get a certain understanding of them. So Tom went away, he followed our direction, and we said, look, you have got 28 days, according to this letter, to put something together. And once you've read the Data Protection Act, the Freedom of Information Act, and the Non-Fatal Offence Against the Persons Act, and we're convinced that you have good insight and a fairly good handle on what has been said there, draft up a letter, send us the letter, and we'll help you amend it or edit it accordingly and appropriately within a legal framework. So very simply, you'll see there in chapter 1 that the letter is actually there. We've put in a copy of the letter. We've obviously taken the man's name out of it, and we told him to go away, take the letter, photocopy it, highlight the points he thought were important, underline the things that he thought were more important, and then frame a letter of response around what he thought was important. So he did just that. He went away, he read the acts that we recommended, and then he sat down once we this and he reread Laura Skelly letter, and I think its title there is She's in the Collections Department.
The letter, while it is a standard letter that a lot of people who are in arrears get, it's also a very frightening letter for anybody who hasn't got it before, because it says in the letter that the bank is now entitled to recover possession of the above premises. That's in the very first line, and I mean, that's the type of line that will really get people's fear up. Yeah. Well, you see, according to the bank's terms and conditions under the alleged mortgage or the alleged contract, they will have that wording in there to state that if you fall into arrears, and generally in most alleged contracts or mortgages, alleged mortgages, they will have in there that if you're in arrears within a period of 2 to 3 months, they then will have the contractual right, according to terms and conditions, to repossess. So it's actually a good point to sort of get sidetracked onto as well, John, because we know that there is other
people out there at the moment giving directions to people on this sort of issue. But you have to keep in mind that as soon as you go into arrears, or if you default on the amounts of money that was agreed with the bank at the time, i.e., let's just say that you agreed to pay them €1,000 a month, and that included interest and capital. If you turn around over a period of 2 to 3 months under their terms and conditions and give them only €100 a month,
yep.
People have this misconception that they can walk into the court and the judge will look at them and say, well, fair enough, the man or woman is at least trying to meet their the things that they're owed, so on and so forth. Now, to be blunt with you, judges don't really think like that. And it's a misconception for anybody to think or believe, for that matter, that they can walk into a court and the judge will actually look at them and say, well, look, at least the man is trying. Because the bank are there to enforce the perceived contract or the alleged contract. And that's what it boils down to with the judge as well. First of all, the judge will look at two very important things and fundamental to contract law. And the first thing the judge consider is, was there an intent by both parties, or in some cases one party, to contract? And as far as the judge is concerned, if there is an alleged contract in place, that proves the intention. Okay? So already you're 50% scuppered, irrespective of the fact that you might have been trying your best to give something to the bank. And the media would have you believe that at least if you're giving something, it's better than nothing. But in effect, giving something is still the same as giving nothing in terms of the alleged contract.
Right. So
the judge will look at two aspects. One is the intent, and then the second part would be the performance. Have you demonstrated, or is there demonstrable proof of performance on your part? Okay, now performance is a two-way street, obviously, but the judge will look at this. Was there intent on your part to contract? And as far as the court is concerned, at that point in time, you wouldn't be in court unless there was a contract or an alleged contract. And then secondly, can the bank demonstrate that there was performance on your part which actually ties you in even tighter to the alleged contract? And if you have been given the bank any money, as far as the judge is concerned, if you haven't challenged that at any point in time, if you haven't challenged the performance or the contract, as far as you're concerned, then you're guilty. You're guilty as charged by the judge. Irrespective of this, and I hate using this word, but it is actually a load of bullshit that goes out there to say, well, at least if you're giving the bank something, it counts for something. It doesn't. It doesn't contractually, and in the eyes of the court, count for anything, because the bank are there to enforce this alleged contract, and they have all the ducks lined up. They have it all ready. So primarily, for most people going into a court, it's a scary place, and therefore they try to reflect that. The bank will try to reflect that, and they know that psychologically most people are very, very, very scared of what's going to happen or what may happen in court.
Right.
So that's why they're very keen when they write letters to like this, like the one you can see in the book by Laura Skelly, to put in the right words. So recover possession, as you said, of the above premises is one set of wording, and then they go on to talk about against you for a court order. So they bring in, and they've actually mentioned this, the court. I think it's in 3 lines here. They mentioned the circuit court once, they mentioned the circuit court a second time, and again, as you said, or as I said, again, they mentioned this word, against you for a court order. So they're actually using the language that will actually drive fear into people.
Yeah.
So that's by design. But again, it goes back to contract law. And if you can't get your head around this idea, well, what do the judges look for? You're wasting, I think people are wasting their time if they're already in default. And you're in default if you have not given the amount agreed and given it over all of the time. So again, if you fall into default by 2 or 3 months, as far as the bank are concerned, contractually and legally speaking, within the terms and conditions of the alleged contract, they have the right to take possession and or take control and or sell the property. Yeah. And that's spelt out within the terms and conditions. Now, the problem, of course, for us is that when people come to us, the first thing we say to them, have you read the terms and conditions of the contract? And 99.99% of those people that walk through our door or speak to us on the phone or email us have not read the contract or the alleged contract. So this is the hard part for us. We have to convince people to a certain extent, go back and read the paperwork. and then you can have a clear understanding. Because to us, in effect, paying 50 quid a month or 50 euros a month or a week or whatever it might be has no bearing on the alleged contract.
Right.
So, that will filter through and people will hear that. But you have to get your head around it first of all. Now, so when Tom got the letter from Irish Life and me, we simply said to him, look, go away, analyse the letter, go away and analyse these acts, and then come back to us and try and draft a letter appropriate to what is in the acts and appropriate legally, so you don't, again, incriminate yourself in anything that's been said. So he did that. He went away and he drafted up a letter, and it actually wasn't bad first time round, and then we sort of tightened it up with him.
Okay, and what was the crux then of the letter that was drafted back?
Okay, so again, we said now hold fire on this letter, because we wanted him to be happy that what he was writing was going to be something that was in his head as opposed to what's in our head. Because that way, if he writes the letter and he fully comprehends what he has written and the context in which he's written it, when or if the bank did come back at him, he would know how to respond because he wrote the letter and he has a comprehension of what's in the letter.
Sure. So
we said, look, Tom, hold fire on that letter. And what we know in legal land, for example, now look at, unfortunately or fortunately, we operate from the perspective that we try to understand what happens in legal land and then guide and direct people in how to deal with the legal issues. So we said your best foot for this stage is probably not to respond straight away to this letter, not to send in a legal response to it, but to go down a slightly different avenue and then come back afterwards and respond to this letter. So we said your best foot forward now is to write a data request. So we have actually, I think we've got a copy of the data request that he sent in chapter 2.
Yeah.
So chapter 1 talks about the language, as you've mentioned, in Laura's letter. And we tried to get into a bit of a diatribe on explaining that, and we talk about exactly what a criminal cabal is all about, and we explain that, and that's actually something you can find in Wikipedia as well. But just to put this in here, we're going to constantly refer to the criminal cabal as i.e. that's Permanent TSB, Irish Life, and that's the reference we're making to them.
Yeah.
So a cabal, as defined by I think it's the Wikipedia definition, cabals are sometimes secret societies, which we know that there's a lot of secrecy goes on around the state and the government and the regulatory bodies. So cabals are sometimes secret societies composed of a few designing persons and are at other times are manifestations of emergent behavior in society or governance on the part of a community of persons who have well-established public affiliation or kinship. So we thought the term was very, very relevant to what we discovered. Now, we obviously, in retrospect, we looked back at what had happened, and then we looked at, well, that sounds like it's criminal cabal. And when you finish reading the book, you'll realize, well, actually, that is actually what's in place on this island. The state are, and if you like, the vestiges of the state would be the government, the different state bodies, the semi-state bodies, the central banks, so on and so forth. But the state themselves are acting as the overlord for little sects or groups of criminal cabals. So that's why we make the reference. And the Irish Life themselves, Permanent TSB, comprise of certain behaviours and personalities and persons in there that have actually carried out an awful lot of damage to people. So thus we identify them as a criminal cabal.
Right.
I know that's kind of a sidestep to what we're talking about, but having said that, within Laura Skelly's letter, you will see, and you've pointed this out yourself, John, the language that's used. So we want people to get their head around the language and what they're saying in the letters, because they're making accusations and they're actually using threatening and coercive language within the context of the letters. So our friend Tom began to realize this, so we said, look, Tom, don't deal with that just yet. Draft up the letter by all means, and then we can send it off later. So then he simply sat down, and as we see, I think it's on page 36 of the book, he wrote a simple data request to the bank, and that was it. Yeah.
And that's something that anybody is entitled to do. Quite often, the misguided conception that any of the information that a state body or a bank or whoever it might be has on you, that's theirs to keep. But that's not the case at all, is it, Des?
No. anything they have, any information, data, so on and so forth. Now, all information, not any, but all information that's related directly or indirectly to you and or to the account they're making a reference to, all of it you're entitled to. And everybody is. Now, we strategically looked at this. This is a strategic move. It's like, I think we associate this with perhaps a game of chess or something like that.
Yeah.
But this is a strategic move because we said on several occasions, and we say this to people all the time, you actually have got the time if you know how to get it. So this, by putting in a data request, you're actually getting yourself or gaining yourself another 40 days at the very least. The bank's hands are tied once you put in this data request. And even if you're in the court, now I spoke to someone yesterday and he's up in court for an issue. And I said to him, and he has actually got a solicitor on record, and I said, did the solicitor put in for a data request? And he said, no, but why? And I said, well, obviously you can't put a defence together unless you have all information. And he said, well, that makes sense. He said, but why would we do that now? And I said, well, look, you're considering taking the solicitor off record. And I suggest and he wasn't very well versed on the court procedures and so on and so forth. So I said the best thing to do, in my opinion, would be to go through the solicitor at this stage, and laterally you can take her off record anyway if you wish to do so. But the solicitor will have then a reasonable reason to go into the court and look for an adjournment, which gives you more time. Now, the adjournment has to be at least 40 days, because if you put in the data request this week and you're in court next week, the court will look at this and say, well, it's going to be at least 40 days before this man gets the information.
Yeah.
So on top of the 40 days, you should be looking for maybe 2 or 3 months on top of that in order to get time to put your defence together. Because you can't be expected to put a defence together after receiving the information within sort of 40 days and then having 20 hours to do it.
Yeah.
So solicitor and or him, if he wants to represent himself, to walk into the court and say, look, Your Honour, or judge, or whatever they want to call him or her, I need an adjournment. And the judge will say, well, why do you need an adjournment? And he'll say, well, look, I put in a data request. It does normally take about 40 days, and I may have other requests as well. And on top of that 40 days, I'll need 3 or maybe 6 months to put together a defence.
Yeah.
So the judge has to be seen to administer justice fairly. The judge cannot turn around and say, well, look, I think that this case is open and shut and you don't need the information, blah, blah, blah. The man can then argue, well, this is unconstitutional and you're trying to rush me to judgment. So this letter alone gets people at any stage, even when they're in the court, at least 40 days, if not longer. So it's a very important letter, and it gives you all the information that they have. Now, coupled with that, John, and I might be ranting on a bit here, but stop me if I am, if you want to intercede. If you send off the data request, it also then, apart from the time that it gives you, when or if they send back all the data that they have on file at our record about you, you should sit down then and catalogue all of that information, as in, you sent me this, and this, and catalogue it fully so that you sent me this letter headed blah, 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 containing pages 1 to 5, and they go on to the next thing and the next thing, and catalogue everything, and then send that letter as a letter back to the bank and say, thank you very much, we are now in receipt of this information, reference the attached catalogue of information.
Yeah.
And that then precludes the bank from bringing in any further evidence at a later stage.
That could be quite important as well, to stop any kind of dirty tricks.
Absolutely. Well, this is the point of doing it, is that you're precluding the bank at a later date. If they say, well, actually, this letter was sent and that letter was sent and we want to bring in this, and you can say, well, actually, that is inadmissible.
Yeah.
Because now they've more or less lied or perjured themselves by saying, well, we gave you only half the information and we're going to use this information against you. They legally cannot do it. They lawfully can't do it. So, but again, it's down to the man or woman to turn around and say, well, actually, I never had that information, so therefore it's inadmissible in the court, and they're using it now to create the idea that I'm actually doing something I'm not doing, and so on and so forth. So it is an arguable point then that they've gone and they've been duplicitous, they've hidden information, and withholding information or stifling or suppressing evidence is criminal.
Yeah.
you're not, this is where we all need to be thinking about, well, when or if we should be involving the Garda Síochána in what we do, because a lot of these operations and, if you like, cabals operate from the premise that, well, we won't tell them what we know, but we'll use it against them at a later date. But if they have been asked and they have been found to withhold information, evidence, so on and so forth, that is a criminal act. And all banks have done it in the past. Yeah. And, hand on heart, we'll be able to prove that. We have proven it in some cases, but we'll go on and prove it and continue to improve it. But this is where possibly you should be considering, if it does come to that where they have withheld information or suppressed information, because I know there's a lot of people out there will have already written to the bank asking them for certain information and will have been ignored.
Yeah. But
that too is evidence. That is information that you should be sent a copy of. So if you have sent a letter off to the bank in the past and then requested a data request, information, so on and so forth, and they haven't included any previous correspondence that you had, they're stifling and suppressing that information and evidence, and that is criminal.
Okay, so the request was sent off, Des, and what kind of response did Tom get then?
Well, look, there was a lot of toing and froing in those 40 days. And just to sort of, if we're jumping ahead, I can tell you now he got no response. He didn't get any data or information from the bank, nothing whatsoever.
Okay.
Now, there's probably other reasons as well, but we'll probably cover that laterally. But in summary, he didn't get any answers. He didn't get any information or data, but strategically we set out to mess their internal systems up as well. So this wasn't, I don't know if we made this analogy before, but we set out with the man Tom to pick a fight.
Yeah.
Okay. And we already knew from the get-go that this is probably a fight we were going to win, because we strategically worked out what we were going to do. And everything seemed to fall into place because we've gotten to know how the banks operate. We've gotten to know how the solicitors operate and so on and so forth. So strategically, we were mentally and if you like, literally prepared, because we'd written this sort and form of letter before and in the past. So we knew by putting in subsequent letters after the data request was requested, sent in, that we could then mess them up entirely by asking further questions as we went along.
Right, and of
course,
which
we will talk about in later chapters, I'd imagine.
That's it, and as we've learned up to now, the worst thing in the world from their point of view are questions. They just don't deal with questions. That's right.
Look, you'll see that, John. I actually don't recall how many letters were actually written. I know at one stage we were sending out. There was a week period there where I think we sent in the region of 100 letters in totality.
Wow.
It cost a small fortune posting these things off. But look, it was worth it in the end because the man came out the other side.
Yeah.
So they don't answer direct questions, but again, you have to be extremely careful how you frame those questions. And as we'll hopefully make constant reference to this, you should not incriminate yourself by making statements of any form or sort. It has to be questions. And I mean, one way of framing any question is putting a thing in front of it and saying, is it true that such and such a thing happened? And just leave it at that.
Yeah.
So what you're asking them are questions whereby they can only answer yes or no. And again, no matter what sort of formal letter they send you, you should be questioning every word, every sentence, if possible, that they have. Now, obviously, there's language that they use will be inconsequential, but there will be phrases and phraseologies that they use that you need to look at and think, well, what are they saying here? And how do I challenge them in terms of asking questions on that statement that they have made?
Yeah.
Now, the more statements they make, the better, because they then are incriminating themselves. But you'll find that most banks, and then when it eventually does go to their legal department or they outsource it to another solicitor, that they tend to keep their information and their letters very, very tight and very, very short, so they don't incriminate themselves.
What we've gone over there, Des, are essentially the opening skirmishes in the battles and the wars that are still to come. And I think it's a very good place to leave it for this week. Of course, we'll be delving in further depth next week. Is there any other point you want to make, maybe just to tie things up for today?
Yeah, I think the final point I'd make is that everybody should read the Data Protection Act, the Freedom of Information Act, and the Non-Fatal Offence Against Persons Act. Now, read it in line with reading what's in the book in the first 2 chapters. And the first 2 chapters have already been published on PDF form, and they're downloadable free anyway on irishlifeandme.com. So everybody now has got themselves 40 days. If you haven't done a data protection request before, you now have bought yourselves 40 days. Now, by the time we're finished with this book, John, and putting the information out there, and we're going to do it piecemeal as we agreed, everybody will have bought themselves at least 2 years.
And that's a lot of time.
It's a lot of time to learn, and it's a lot of time to get your head around what's happening. Now, again, if you're listening to this radio interview, I'd also say to people, get others to start from the first radio interview that was on part 1, then work your way to part 2, and don't jump around. Just listen to or read the book in a way that you're reading it or listening to it cover to cover, and then go back again to the start. And because you learn something else, we'll try and get into as much detail as that is humanly possible. And John, hopefully, you'll have the relevant questions to ask me, so as we can actually drill down into some of the issues that people might have. But the aim here, in terms of putting this YouTube video out and putting the book out, is to let people know that they do have the time, and at the very, very least, before it ever goes to court, you can actually get yourselves, now if it isn't in court already, you can get yourselves at least 2 years, if not more. And 2 years is a lot of time. It's a lot of time. It
is, and I think once people are prepared to put the work in, it's a huge comfort then as well to realise that you do have that time.
Yeah, absolutely. So everybody now from this interview has 40 days. If you haven't sent off a data request before, you have 40 days. So you need to get that into your heads. Relax, study, take it easy. I don't think you can study whilst you're under pressure. I think you have to find a way to relieve the pressure, and this 40 days will relieve a certain amount of pressure. And then within the 40 days, hopefully we'll have another chapter or 2 or 3 or 4 out, and then you'll find the next steps you could possibly take in relation to engaging with the bank on a legal basis.
Fantastic. Well, looking forward to delving in further. Give us the website details again, Des, for those who might want to check them out, please. Very
simple. We're www.irishlifeandme.com, and equally you can get in touch with thecommonlawsociety.com, and I think that there was a reference to your YouTube video on there, John. It should say thecommonlawsociety.com, just for clarity.
Perfect.
And as I said, it's irishlifeandme.com. We're on Facebook as well. If people type in Irish Life and Me into Facebook, you'll find our page there, and you can comment on the book and so on and so forth.
Fantastic. Well, great stuff as always. Keep the faith, Des. We'll talk to you again next week. Thanks for joining me.
Thanks very much, John. Take care now.